In the course of our series looking at the ways in which law is made in England and Wales, we're going to start to talk about the way in which the parliamentary system operates. Now, we took a brief introduction to this in the previous lesson when we explored the nature of parliamentary legislation. We talked about the various types of legislation that can exist in terms of the types of where legislation essentially begins with white papers and green papers. We also talked about the general structure of Parliament with the House of Lords and the House of Commons, and the influence of bicameralism within the UK's legislature. This lesson is going to talk about the establishment of bills, talking about the types of legislation that can exist. And by legislation, I'm being specific about bills that are passing through Parliament and could potentially receive royal assent and become acts of Parliament. That's essentially what we're doing here. We're talking about the process of lawmaking, more specifically, looking at the process of legislation and how legislation may be passed as time goes on. So ultimately, a, a bill which has gone through Parliament, a law which is created by Parliament itself, statutory law, is known as an Act of Parliament. It is an Act of Parliament as soon as it receives royal assent and is entered into force. Acts of Parliament represent primary legislation in the United Kingdom. Essentially, all other lawmaking authority, in terms of the kind of legislative lawmaking authority, is subordinate to Parliament. This is, of course, part of the doctrine of parliamentary sovereignty, or the principle of parliamentary sovereignty, whatever you want to define it as. Before a piece of legislation becomes an act of Parliament, however, i.e., before it receives this royal assent, it has gone through the process of the legislative process of creating law. An act of Parliament is actually known as a bill, and a bill will then go through the various stages of the parliamentary process and then eventually come out and become an act of Parliament. So essentially, we're not focusing in this lesson on the process by which legislation becomes a bill becomes an act. We're talking specifically about where bills begin their life. So we'll talk about the different kinds of bills that exist. And then the next lesson we'll talk about the various stages of the process that take a bill from its beginnings and its inception all the way up to potentially royal assent. So, bills are often started by government ministers, and they're often started as part of and a matter of policy. So, they often start as white papers and green papers, which then get formulated into legislation or potential legislation, and they form part of government minister policy because, of course, when a general election takes place, an individual party will put forward a manifesto, which is the kinds of policies that they want to implement if they were to become elected. And so these matters of policies are what essentially the government ministers are going to formulate in the creation of new law. However, this isn't the only kind of bill that can exist. There also exists what are known as private members' bills. Now, a private member's bill is created and introduced into Parliament by private members of Parliament. A private member of Parliament is a non-governmental member of state, so somebody who is not a minister of state, not a member of the government, but is actually instead referred to as a backbencher because they sit on the backbenches of the House of Commons, not the front benches. The private member is not a formal member of the government and so does not sit in the front rows of the House of Commons. That is essentially the way in which it operates. Now, private members' bills, for the most part, owing to the timetable of Parliament and owing to the dominance that the government has in having a majority over the elected members of Parliament, essentially means that they very rarely ever receive royal assent, these private members' bills, because they often die before they can even get to that stage. There are notable exceptions. For example, a private member's bill, which was quite a significant piece of legislation that was passed, was the Abortion Act of 1967. So there are still examples where there are private members' bills which actually do have significance and do actually manage to pass into law, but for the most part, they are a very rare occurrence. One of the reasons why the private member bills are so difficult to get through is because they are relatively difficult to introduce to Parliament in the first place. There are two methods by which a private member's bill will become entered, could actually become part of the process and entered into Parliament and introduced to Parliament in the first place. So you have what is known as the ballot process, and then you have what is known as the 10-minute rule. Firstly, then, the ballot process. The ballot process is a process whereby each parliamentary session a ballot is allowed. Here there will be 20 private members of parliament who are able to present their own vision for a bill that they want to enter into law to become legislation. It is a very limited process, of course, owing to the time constraints that exist within parliament, and so as a result of which very few private members' bills are introduced through the ballot process. 10-minute rule is the rule which tells members of parliament that a private member may be given 10 minutes to present a bill and a supporting particular piece of legislation. And essentially, just like with the ballot process, this 10-minute process allows you to present your vision for a piece of legislation, for a bill as a private member. That doesn't mean that anybody is going to vote for it, and it's even going to have any chance of being introduced into Parliament. Again, just like with the ballot process, it is an unlikely method for creating new law. There are other ways in which we can divide bills up as well. There are divisions of bills which can be made on a public-private dichotomy, a public-private basis. These types of bills don't necessarily refer to the people in Parliament who present them as legislation, so they're not private members' bills in the sense that they are presented by members of Parliament who are not government ministers. They more are concerned with the interests in which they are looking to regulate. It denotes the interest in which the legislation looks to essentially supervise over. So a public bill will be proposing legislation that is intended to influence and regulate matters of public policy, the public as a whole, whereas a private bill will look at the impact on a particular person or, as is often the case, an organisation, an institution, or a corporation. So, for example, the example that was cited by Martin and Price from 2017, is the introduction of the Faversham Oyster Fisheries Bill of 2016 as a significantly private member bill, as you can probably imagine. The Faversham Oyster Fisheries Bill from 2016 does not concern itself with as a matter of regulating public policy. It concerns itself with a very private institution, a very private specific type of individual in the public. Finally, then, you have hybrid bills. Hybrid bills, as the name suggests, are intended to cut across this public and private divide that exists that we found here on the previous slide. They will be introduced by government, but if they are passed, they may have an impact on a particular organisation or community. So essentially, they look to essentially bridge the divide between the public and the private in regards to the type of legislation that could be passed through to Parliament and then ultimately receive royal assent.